Are we live? So we're almost done with the recruitment, the labor certification process. So we have submitted to the state the job order for them to do their recruiting. While they're doing their recruiting on the job banks or the various state job banks, we as an employer have to do 2 newspaper ads. One must be a Sunday. We have to physically post that ad, the job order, the job description in 2 conspicuous places at the work site, and that's for 15 business days. Okay? I understand that many of your businesses are going to be closed. You've just got to go into your office and stick them up somewhere. Okay? For 15 business days. You don't submit the physical posting, you put it back into your audit file. And again, if you're a company that's large enough, Linda, maybe you guys, if you have an employment electronic notice system where you send out notice to all your employees, you can put the job order on your electronic posting as opposed to each work site if you like. Okay? Although it gets a lot of attention that way, but it's up to you. Again, you can notify, or you may be required to notify any unions or any other areas that are underemployed or associations that have available employees. All of this stuff has to be done within 14 calendar days of receiving the notice of acceptance, and has to be completed within 10 calendar days. Okay, and they will give you a very specific due date. Again, the only thing you can't do within the 10 days, or the 2 things, is the job order. You can only explain what jobs, what U.S. applicants applied during those 10 days. But again, the recruitment on the job order goes until 21 days before your first day of need. And the other thing is the physical posting will go 15 business days. Once it's complete, you sign it, date it, and put it in your file. Okay, let's see here. So, one of the questions that came up is, do I have to pay for the college kid that's at University of Washington or University of Arizona to come and work, because that's in your recruitment? Yes. Okay. Do I have to pay for that unemployed employee in New Orleans that sees it on their state job bank that applies for your job and you can't disqualify them after telephonic interview? Yes. Or they won't certify your perm. Okay? So, at the wrap-up stage, well, let me just see here. So then you have to submit in the 10th day your recruitment report. You have to sign it, and you don't submit it with supporting documents. All you have to do, it's just an attestation that says, here's all the recruitment we did. Here's the name and contact information of all U.S. workers that applied or referred to us. Here are the offers made and accepted or rejected, or here are the people that we interviewed and they were rejected for lawful job-related reasons only, which are, I don't want to perform that work. I can't work those hours that you're requiring me to work. I can't work from April 1st to November 30th. I can only work until August 30th. All those are legitimate reasons to disqualify U.S. workers. It is not legitimate to disqualify a U.S. worker because they don't fit the corporate style. They don't fit in with your company. They don't, those things that many employers take into account during a live interview. You can request a live interview, but you have to pay for that if they're outside the country, just like, well, how is it that you're interviewing your Jamaican workers, right, if you've never met them before? So whatever you employ for them, you have to employ for U.S. workers. You have to state on your recruitment report that you've notified everybody, that you've notified all laid-off workers within 120 days of your date of need. So that means if April 1st is the beginning of your first day of need, and you closed your office, your store in December 1st, that's inside of 120 days. You have to notify all workers that were released in that occupation that this job is available again on April 1st. The regulations in the comment sections specifically state that if you want to avoid this notification of the prior year's workers, stay outside the 120 days. All right, so that would be April 1st to November 30th. And that will, if that's the maximum season you have, then that leaves 121 days in between, which means you don't have to notify everybody you laid off the prior year. Okay? And that you confirm that you've done all of the other directed recruitment that was ordered by the state. So you went to the Career Center, you interviewed everybody the Career Center sent you. We talked about this, the job order, although you're going to submit this recruitment report within 10 days, the job order is going to stay open for 21 more days, for a period of time up until 21 days before your first day of need. So if April 1st is your first day of need, even though the recruitment and the wrap-up's done in January, the job order stays available up until March 6th. Again, everything that supports this recruitment must be kept in your files. Do you have the microphone?
No.
Yep, I'll repeat it. Yep.
Have you, and maybe to Jane also, have you found that with respect to these that have been submitted, and I know we haven't got up to the 21 days necessarily yet, have they required, has DOL required a written follow-up recruitment letter to be submitted to them?
So the question is, what is required after you've done the initial wrap-up at the 21-day before your first day of need? At that mark, what is required? The regulations don't state what you're supposed to do. And that's why I stated earlier that in my best legal advice would be to decrease the number that's been certified at that point, record that the U.S. worker was interviewed, and put it in your audit file. Because the state will have a record of that somebody applied for you. That applied for that job inside that, between that window of when you've wrapped up your recruitment and the 21 days before your first day of need. So I'm telling my clients, decrease your number or your request by that number of U.S. workers that you ended up hiring up until 21 days and save all that documentation to be audited for the following year.
But not necessarily having to file a follow-up letter with DOL.
I have not found anything from Department of Labor or the state that says you have to file anything if you hire U.S. workers after the wrap-up before the 21 days.
It's the same with us. We have not had anyone come back and ask, and we have approved labor certificates under this new process. We've just kept it in the audit file, and we've actually had, every position has had workers submitted to us after we've submitted everything to the Labor Department and have come back and still have the job on the job bank, even though we've submitted to USCIS. We are getting American workers, but we don't have to send anything in. We just have to keep it, but it is a nightmare to manage.
So once you've submitted this wrap-up within 10 days, the certifying officer can certify it, partially certify it, deny it. Partial certification would be you asked for 10, you've advertised for 10, you found 2 SU workers, they're going to partially certify for 8. Deny it, request more information, or then ask you to do additional assisted recruitment. Technically, the employer can request the CO to modify the number of openings, the dates, start recruitment. Again, within that 20% and less than 30-day change, you may be able to change that, but it will probably require you to re-register. All right, so I don't recommend that. Extensions of the registration period is possible, unlikely in the event, unlikely other than in the event of natural causes or conditions outside of control. So what that means is, listen, you have landscapers and you need them until September 30th. Hurricane hits in the middle of September, and now you need to employ them for October. Could you ask for an extension? Technically you can, but it states that it would have to be of that nature, totally outside your control. Not, hey, we just got a contract and there's 6 more tour buses that are going to come to our restaurant in November and we weren't going to be open in November. All right? It's natural, uncontrollable conditions. Findings. The CO can certify you. They can require assisted recruitment. They can revoke if they do an audit in the season. they can debar you from the system, from the program for 1 to 5 years. This is new. Now there's up to a $250,000 fine and 5 years imprisonment for willful violations. All right? Before there was only civil penalties. Now, if you were purposely violating these things, that it's potential that they could be referred from the Wage and Hour Department up to the U.S. Attorney's Office, and you could face up to 5 years in prison. I've never heard of that. Most of it is, the worst you're going to find is that you're going to be debarred, not allowed to participate in the program for 1 to 5 years. All right, so that's the process, okay? And again, I am very confident that Mark's office, Jane's operation, my office, that we can get you through the process and get you a labor certification so you can go to USCIS. We will all tell you that it's going to take longer, that all your people will be late. So if April 1st is when you want, but you can't even start the recruitment until 90 days ahead of time, plus you've got 10 days to do all your recruitment, plus you're going to ask for expedited premium processing USCIS. We'll be lucky for an April 1st date if we start everything on the day 1, January 1, if we get a labor cert approved by first week of February, okay? And then you've got to do premium processing. So if you're lucky, maybe the middle of March will you get your labor cert and your USCIS approval so that they can start going to the embassy. It's not going to happen, all right? Everyone's going to be late. And the process is, it is what it is. They don't care, okay? They want you to keep the job open for up until the last moment, essentially, to find US workers. I think, so those first 20 slides or 15 slides were kind of mind-numbing, but you know, that's what you're paying Jane and Mark and my office to do, all right? We'll get you through that. The next 10 slides are your obligations as an employer. This is the stuff you have to do, or you're going to have H2Bs for only 1 year. Because when they audit you for 2016 and 2017, you're not going to be in compliance, okay? And this is where the rubber meets the road. Because a lot of these, don't forget, the Wage and Hour Department, the Department of Labor, can do the investigations and levy the fines. In Massachusetts, if you're purposely violating wage laws, they're treble damages, okay? And that's for all U.S. workers in the same occupation. And I believe all J1s as well, okay? You can't say J1s are a different program, they're not included in this, okay? So it's everybody in that occupation that you brought an H2B in. You bring one H2B, they're going to poison the well for everybody in that occupation, okay? And we're going to see how far that reaches out in these obligations. You must offer the same wage, benefits, and conditions to all workers similarly employed, free and clear. You have to guarantee 3/4 of all available hours. You have to actually produce and give a very specific wage and earnings record. You have to pay travel subsistence costs, plus Appendix B, which I gave all of you in your handouts, used to be 2 pages, is now 3 pages, and there's 27 obligations you have as an employer. Read Appendix B. You all have it. Everything I'm going to state here is in Appendix B. And you have to maintain an audit file. Wages must be free and clear, unconditional. No deductions from pay other than required. We talked about that. Every condition, every deduction, every benefit must be stated on the prevailing wage form, the job order, and advertisements. If the deduction is not stated, it is prohibited. I don't care how voluntary it is. You have to guarantee 3/4 of the wages, even if a tipped or piecemeal or incentive-based position. So if it's a tipped position, at the end of the week, you have to guarantee 3/4 of that pay. You must define a single work week, and that must be included in the recruitment. So 168 hours, it starts Sunday at 12 a.m. and Saturday 11:59. They will be paid weekly. That is required. All right, again, your work week can be stated differently, but it has to be stated so that everybody knows what it is. You must pay wages no more than 2 weeks apart. We talked about that. You must offer work on the first date of need if they're in the U.S. and you've got an approval, or within 1 workday of arrival. So the wage obligation starts, if they're late, they show up April 1st, whether they're actually physically at your job or not, because they're stuck in LaGuardia, you get it, the wage obligation begins April 2nd. Offer of work continues until the end of the H2B certification period.
Excuse me.
Yes?
On that wage obligation, the starting date,
Yep.
if you look very carefully at that, right, it says that the date of need or their first start date, whichever is later. So as I read that,
Correct. So that means if they don't show up on the first day of need, so you've asked for April 1, but they don't show up until April 15th because it delays at the embassy.
they don't start until April 15th.
Correct.
Okay, and in terms of the April 2nd date that you, example that you just gave,
Yep.
I would beg to differ. If they're delayed and it's not related to you, that is, that you're not, it's not because you're not starting them on April 2nd.
Oh, right. 'Cause they haven't actually arrived at your job site yet. So Mark's point was that it's whatever's later. So the first day of need is April 1st. If they don't arrive because of delays in travel until April 3rd, that's your arrival date. So then you have to start the payroll obligation April 4th. I think that's a reasonable reading, whichever later, okay? You can't bench them. You can't hide them in Vermont if they're in the U.S. until May 1st when you really need them, okay? All right. Wages, continued obligation. Employer must offer all pay and wages to both its H2B workers and workers in corresponding employment. All right. Now bear with me. This is where that wage payroll document comes out. Corresponding employment means those non-H2B workers that are performing substantially the same work as described in the prevailing wage job order, or those job duties that the H2B is working. What do they mean by this? This is what they mean. If you are an employer and you bring everybody in as a dishwasher at $10 a prevailing wage, but they're really working even one day as a line cook that should be paid $13 a day, this language states that because you have to pay the same benefits to all equally employed workers, US, J1s, everyone. If you misstate and that dishwasher is really a line cook, now you've created the obligation to pay every line cook that you have $13 an hour. So all those US workers that are making $10 an hour, by placing that H2B as a line cook when they're really supposed to be a dishwasher, you are obligated to now, you owe all those US workers during the same period $13 an hour, and they have a right of action against you. So you can't misstate what your people are doing. Okay? Even if it's for one day, now you've poisoned that whole category of workers. Further, if they're, that's why it states, for those non-H2B workers that are performing substantially the same work as described in the prevailing wage. So that includes when you've honestly stated that your worker is dishwasher, all US corresponding workers have to be paid the prevailing wage that you're paying that H2B worker. Does that make sense? Except for if it's an incumbent worker. All right. An incumbent worker is not a corresponding worker. These are people that you do not have to treat exactly the same as an H2B or other seasonal workers. An incumbent worker is one that has continuously been employed doing substantially the same work for 52 weeks prior to the first day of need. So that means from April 1st, 16 is your first day of need. You've employed this person since April 1st of 2015 to be your full-time year-round dishwasher. And plus those others. They've worked or been paid for 35 hours a week for 48 of the prior 52 weeks, have worked or been paid on average of at least 35 hours per week over the prior 52 weeks, and the terms and working conditions cannot be reduced over the H2B period. So it used to be on that payroll form that you had full-time year-round employees on the right side, and you had temporary workers on the left side. Now, the definition of a full-time year-round employee has just been changed. they're not a full-time year-round employee unless you've essentially hired and paid them to do that work for at least a year prior to the first day of need. Which means if you hired a cook, a dishwasher full-time 6 months ago to be your cook year-round for, I think, for the payroll report purposes and for these regs, during the H2B period, you have to now pay them the H2B wage. It used to be that they were considered full-time year-round, but they're not. If you haven't employed them for a full year, they're entitled to the same wage as the H2B workers. Okay? So it's only a full-time year-round worker if you can prove that you've employed them for at least a year and they've been working 52 weeks, 48 out of 52 weeks, and they've been being paid the average wage over those 52 weeks. Okay? So getting back to the payroll report, I think the payroll report now has to be incumbent full-time workers on the left side, and everybody else is considered temporary seasonal on the right side. So that means when you're doing that report for Jane, Mark, or I, that everyone that you consider to be full-time year-round, they have to be defined as an incumbent worker. That means you've employed them for a year, and you better have documentation. Because in an audit next year, they're going to say, prove to us that this person was an incumbent worker, and they weren't, they were not required to be paid the same benefits as the H2B worker. Yes?
How is that going to affect then that interpretation, the definitional provisions with respect to peak load and seasonal? Because now, if I'm open year-round and I'm on a peak load need, but my peak load is very different between the seasons.
Right.
I'm still open year-round. I might have the line cook working only 25 hours instead of 40 or 100 hours a week in my peak load during the busiest part of my year.
Jane, can you give him the mic?
That's why I make for it.
Right. If I can summarize your question, because you have peak load need where you have dishwashers that are employed full-time year-round, under this definition, if you've just hired 4 dishwashers within the last year and they're really full-time year-round help, but they don't fit the definition of full-time year-round because they're not an incumbent because they haven't worked a full year, how is that going to affect your peak load?
Now my business is going to go from peak load to seasonal need under that.
Yes, it would. Yes, it would. But it may be a distinction without distinction.
Difference?
Right.
This is what we've done when we've told ours. We've told folks, if you don't have a worker who's been hired at least a year before, you just pay them the prevailing wage and be safe, pay all of your year-round the prevailing wage or higher.
Right.
And now you can complete that wage summary report. Because you're correct, Mark, when they go to do their interpretation of that wage summary report, they're going to interpret it differently and say, you don't qualify for H2B anymore.
Right. And technically, the regulations state that those incumbent workers that are working there only have to be paid the prevailing wage during the period requested. But good luck to you to raise somebody's wage and then tell them on September 30th when the H2Bs leave, they're now making $10 an hour again from 13. Technically, you can do that. Good luck having that conversation with your employees. All right. Okay, so that's one of your obligations. You have to treat everybody in that same occupation the same. It's that simple. And any employee that's in that position, whether you define them as full-time year-round, if they don't meet this incumbent worker definition here, they are part of your seasonal workforce. So if they haven't been there a year, they're part of your seasonal workforce. And they're entitled to all the regs. The question is, does that mean I have to go back and pay them for their inbound travel if they started the job and they came here from Michigan? No. And we'll talk about that in a second. All right, so inbound travel and subsistence costs. You can, now this is inbound, to begin initial employment, not daily transportation, to begin initial, to initiate the season. You can prearrange the travel, you can advance the costs, or you can reimburse them. However, if the employee works at least 50% of the period, So if you have an 8-month period and they work for 4 months, once they've worked 4 months, you have to reimburse them for travel and subsistence costs. Subsistence is Department of Labor's daily cost for food. If it takes them 2 days to travel, you have to pay them 2 days subsistence plus the lodging. Okay? Subsistence cost is what I was able to find, because it's nowhere on the internet. It's on the H2A website. Is $11.86 is the current wage. I don't know what it'll be in January. All right. So whoever you're dealing with, you got to figure out. If you pay around $13 a day for food, I think you'll be safe. Okay. Do you have to offer this to college kids that apply that want a free trip home? Yes. Do you have to offer this if you're doing it for your Jamaicans and your South Americans and your Bulgarians? Do you have to offer this to the unemployed person that finds this job in New Orleans? Yes. It's for everybody that's in corresponding employment. Anyone that's in the same.
50%
Correct.
of the date frame, correct?
Right. So once they've worked 50% of the time, at that point, the obligation is that you have to reimburse them for the inbound travel and the days of subsistence that they're entitled to.
That information also needs to go on your job bank notice and in that newspaper ad.
Correct.
And you also have to say how you're going to reimburse them, not
Correct.
just when. So you better make sure the words by company check are in there. Because if it isn't, they will not approve it at U.S. Department of Labor.
So one way around it is to prepay or arrange for the travel, right? And a lot of employers will buy the airplane tickets. So then the question is, can you, if the employee leaves before the 50% of the period has been worked, can you go after them for the cost of that travel? I would say the regulations allow you to do that, but again, we get into this sticky wicket. Do you want to start suing your employees? And do you really want to start suing an H2B employee or a U.S. worker that's provided H2B benefits, where all they have to do is complete a wage an hour, and you see all these obligations that you want to get into? So for all intents and purposes, I think you're better off just pre-arranging it because you can control the costs, pay for it, and it's a sunk cost. Yes, Brian?
Yes, and paying for inbound travel, and if we pay from, let's say, a flight from Jamaica to Boston, then we need to pay
The bus.
from Boston to Hyannis, and then pay for our cab from Hyannis.
Absolutely right. The question is, for the microphone, whether travel is whether it's just the airplane flight. It is to initiate employment. So if they've got to take a boat, a plane, a train, and Uber to get to your work site, it's all those costs plus the day of subsistence, right? The $13, all has to be paid for, or taken care of by you, or reimbursed no later than once they've completed 50% of the period.
But for the H-2Bs, you have to pay them in their first week of arrival, and that also has to be put into the job bank order and the newspaper ad. So you have to make that very clear, because we kept running into that when we were filing for our winter clients. The newspaper ad and the job order has to say you will reimburse the H-2B worker in their first week of employment by company check, and U.S. workers will be reimbursed once 50% of the job is done by company check. I know, because we kept trying to put it through that we'd pay everybody at 50% on their travel, and they just kept rejecting us and giving us notice of deficiencies until I fixed that language.
So it's the H2B that has to be within a week, but if it's U.S. workers, it's after 50%.
Correct.
That's if you're not paying for or pre-arranging it.
Oh, so that's, if you're pre-arranging, you don't have to be that explicit.
Right, but if you are paying during their travel to you from Kingston and they're on the plane, when they arrive, even if you pick them up in Boston, you owe them $11.86 for that 1 day of travel. plus you owe them for their travel to and from the embassy for the interview, plus you owe them their $190 embassy interview fee. So you have to reimburse that. So we say that, and for our clients, we're telling them to clearly document that in a letter that they are giving to the worker along with that reimbursement check, so you can prove you have covered every step.
So that's what the Department of Labor is requiring.
Correct, right. They came right back and to us in our newspaper ads and in our job order. They would not approve our job order on any of the state job banks until we put right in there. And they gave us the language, very specific language about the workers, H2B workers being reimbursed in the first week for all visa costs, for all travel, for anything that was not already prepaid. And
But
we
we're
had
not
to
talking,
put that.
all right, so Jane, the only thing I would disagree with is that I believe you that that's what they required, but the regulation requires you to pay all visa costs in the first week. But the travel does not have to be paid, even to H2B workers, until 50% of the period has been done, if you're not prearranging it.
We might need to tell the Labor Department that.
Okay, right. The regulations require, so inbound travel, the regulations state that travel and subsistence cost needs to be paid no later than once 50% of that job has been, job period has been satisfied. Visa-related costs, which is what I think the Labor Department is confusing, visa-related costs have to be reimbursed at the first week of employment. So whatever it took them, except for their own passport, every cost that they incurred to get that visa has to be reimbursed in that first week.
If they have advanced,
If they haven't advanced it.
if they have advanced.
Right, if the employee has advanced it. Okay? Outbound travel. The employer must pay 100% of the outbound costs if the worker completes the employment until the certified period is ended or you dismiss them early. If they take off, they quit, they abscond from your employment, that requirement no longer exists. But you better have a notice to U.S. Department of Labor and USCIS within 48 hours saying that they have left employment or that they've been terminated. You are required to pay or arrange for travel to the last place from which the employee departed to begin employment. So if the employee came from Vermont because they transferred from Killington to the Cape, do you have to pay for them to go back to Jamaica if you terminate them? No. You have to pay for them to go back to Vermont or whatever that reasonable cost would be, that portion of their ticket to Jamaica. Okay? Again, that's my reading of it. Yes?
What would you say would be the situation when you have an employee that at the end of their H2B term decides they want to change to a tourist extension and travel around the country? I mean, I have lots of young people that work for me and they're absolutely up for that. So what, would you be paying for them to go home at the end of their 2-month tour around the U.S.?
The way I would do it is from an immigration standpoint, the kids that go from an H2B or a J1 to a B1, it's a kiss of death. They'll never be issued a visitor's visa again at the U.S. Embassy. All right? Aside from that, I would make sure that if you haven't arranged for that travel, that you've written a letter to them that says that we are going to give you $350, which is the average cost on Travelocity for you to go back to Bulgaria. You have 30 days to use it, or here's the check and you get the receipt for it. All right? So long as you make all your efforts to get it done with. Okay?
Let's talk, what about extension workers? 'Cause all right,
That's the second part. All right. So the regulations state very specifically that a follow-on employer, so they're leaving Killington, they're coming here. No, better yet, let's do it the opposite. They're a Cape employee of yours, and they're going to go to Killington. It says a follow-on certified H2B employer is responsible for their inbound and liable for outbound obligations. Prior employers are no longer liable for travel costs home. So as they leave you, if Killington has an H2B certified, then they're responsible for their inbound and you're not responsible for the outbound. The problem is, if you read the reg very carefully, it says a certified H2B employer. Many cases, your Killington Resort is not going to have their application approved and certified by the end of your period. So if it's not certified and approved, are you obligated for the outbound? I would say yes. Okay? Unless they can prove that they have a certified, Killington has a certified H2B employer that's a follow-on to you, then it becomes their obligation. But until their application's certified, you still have the obligation of the outbound. Yes?
Then your recourse is against the new extension employer, because they have to prove that they've paid the inbound.
Correct.
On their end, so.
Right.
You're gonna get.
So then you
$350
get into a pissing match with Killington to make sure that they're reimbursing you for their inbound, your outbound. Okay?
And those employers don't want to share their approval notices with you either.
Okay. Now, all of this stuff has to be documented. You've got to have paperwork that proves that you did all this, that you paid for the inbound, you paid the visa costs in the first week, or you arranged for it, airplane tickets, arrangements, Travelocity printouts, whatever it is, and that you've paid for or you arranged for the outbound if there's no follow-on. Document all of this and keep it in your audit file. Now we're going to go to must guarantee the 3-quarter guarantee. The good news here is that if your employment is for greater than 120 days, so your period of your season is longer than 120 days, you must guarantee 3/4 of the number of work hours equal to 3/4 of the work days in each 12-week period. Basically, and Mark has a handout. He took it right from the wage and hour. So if you grab one of Mark's handouts, it's at the table up front. It explains what this means. What it means is 12 weeks, so in that 12-week period, so that's April 1st, first 12 weeks, May, June, until June 30th. If you say your work week is 35 hours, you have to guarantee 75% of that, so that's 315 hours, either must be worked and therefore paid, or at least offered. If you don't offer it and they didn't work it, you have to make up that difference in the first 12 weeks for every 12-week period. So then the next 12-week period would be July 1 until September 1, and then there'll be an 11-month period if you use the full 9 months. So it'll be 12-week, 12-week, and 11-week. And then there'll be partial weeks in the beginning and the end. And even those weeks, you have to guarantee 75% of the 35 hours. All right? And this is for every corresponding employee. So this is your college kid, your non-incumbent workers. All right? You have to guarantee, if your normal work week is 35 hours, you have to guarantee 315 hours in the 12-week period. The good news is that if you don't have a lot of business in April, and you can only provide your H2B workers and your U.S. workers 20 hours a week, you have until the 12th week to fix it or pay it. Does that make sense? All right, so many of your businesses aren't as busy in April, and then you pick up in May, but by the end of June, if they haven't worked that 315 hours, you've got to make up the difference. This language has to be in your ads. Okay? This is recruiting nationwide. This is what it means, okay? Just like the inbound costs and the outbound costs are in your ads. That's in that language I gave all of you, okay? This 3/4 guarantee was lifted from the regs, and that's in that sample language that I gave you, okay? If your period is less than 12 weeks, less than 120 days, it's every 6-week period. You have to guarantee 3/4 of the wages. Now, hours offered. So if on your prevailing wage you say your normal work week is 35 hours a week, you can't say, listen, I offered 50 hours and they didn't want it. Any hour above 35 hours doesn't count. Okay? But if they work more than 35 hours, every hour worked does count to calculating the 3/4 guarantee. Okay? So this is where you got to be careful what your minimum work hours are. Let's see. How do you, and you're credited though if you've offered it and they've declined it. So if the employee says, no, I've got to go to a wedding, I'm not working this weekend. No, I'm going on maternity leave or Family Leave Act or whatever it is. If the employee declines your 35 hours a week or 3/4 of that, 30 hours a week, let's say, you better have documentation of it. That's got to be in your audit file. So this is an ongoing obligation that you each have as an employer to document when you've offered them and when they've declined it. So it has to be above board on its face, okay? Again, this applies to H2Bs and all corresponding employees. The only ones that are excluded are incumbents, people that you've employed for 1 year. Does this include J1s? I believe yes. Let me go back a slide. So, do you have to pay the J1's inbound costs from Bulgaria? Okay. I looked it up this morning, and this was a question that came up yesterday, right, Brian? Or do you have to pay for that U.S. college kid that you found not during the recruitment phase from Washington, but that just knocked on your door? Do you have to pay for their travel from college? It applies to, the inbound travel applies to those workers who have come to work for the employer. Travel to take the position. So if they're already here, you don't have to pay. My reading of the regulation is you don't have to pay that inbound travel if they're already here. J1s, some of your J1s show up on your door. It's not prearranged. Do you have to pay their inbound travel? No. Those J1s where you specifically called the J1 company, and you remember you have to do an offer of employment before they get on a plane. So if you you specifically interviewed and requested 10 J1s prior to they got on the plane, so they are specifically coming to work for you, I believe this regulation applies. You have to pay their inbound travel. Yes. However, their inbound travel only has to be paid after 50% of the period has been worked. Most J1s only can work for 4 months. So they may never reach, if you have a 120-day period, they may never reach the 50% mark. But this is your obligation. This is the math you've got to do, and you've got to sit down and track. So let me review that again. My reading of the regulation is that travel to take the position is the exact quote in the regs. So if somebody's taking this job and they've accepted the job and they're traveling to start the employment prior to their coming here, then the inbound travel requirement applies once the 50% of the period has been worked. If they just happen to be here when you hire them, they're local and they're commuting, then inbound travel from wherever they may have came is not required. That's my reading of it. Yes, sir.
So J1s are rarely meeting the time frame of the job offer. They're usually arriving long after our start dates in April and
Right.
leaving before. So they're not really, I mean, the substance of the work may be the same, but the fulfilling of the job requirement of April 1 to November 15th is not.
They'll never meet the 50%.
And it's a late arrival, a considerable late arrival.
Yeah, and that's not clear. That's not in the regs. What is the period, right? Well, it is clear that it says the period that you've requested and were approved for. They have to work 50%. So the way I read it is if your entire period is 120 days, or 9 months, right? It would be the 4.5 months, right? So if the J1 never works 4.5 months in that period, whenever they come, they don't work 4.5 months, that obligation to pay their inbound travel doesn't attach. Yes?
But don't their sponsors, don't the J1 sponsors already have the J1 students pay for their
Right, but
fares the employer should meet?
Right, but remember the quote, the clause says you have to reimburse them if once they've done 50% of the period. So let's just say, for instance, your period was only 6 months. Your H2B period was 6 months. J1, you sign a contract with the J1 company, you want 3 J1s. They're coming, and it says they're coming to specifically work for you, to at least start the J1 program. They come work for you. Once they've worked 3 months, you have to reimburse them for the reasonable cost of travel inbound, even though they paid it through a third party, which is the J1 company. That's my reading of the regulation. If the J1 knocks on your door, then they didn't travel based on an inducement, which is your offer of employment. Yes, Mark.
Back on that, on the three-quarter, the big loophole that I do see, however, on the offering to get to the 315 hours is the following. As we know, many of the employees that come on the H2B work a second job.
Illegally.
Right. Some if they're concurrent employment,
Right.
they'd be legal, but
Right.
if not. So if you've offered them in that first April to June period of time to make up that 315 hours, and in the interim, they've secured second employment, illegal or illegally, then if you've offered them the number of hours to get to that 315,
Right.
and they've declined and they say, no, I have to go work my other job.
Right.
As long as you've kept that record, then you,
Correct.
as the employer that brought them in, is secured and,
That's right.
and everything else. And they've taken the option because either they're making the same or they're making less.
Right.
Or
But this is the problem that could come up. The problem is, all right, so you've got a 12-week period to make up the three-quarter guarantee of wages. U.S. workers, corresponding workers, H2B workers. You know that April you're slow, so you're going to offer them 20 hours a week, knowing that you can offer them the full 35, plus most likely they'll work overtime in the last 4 weeks of that 12-week period. What happens if they actually read all the notices you give them, okay, and they say, you know what, I'm going to work you 20 hours a week for April and part of May, and then when I come in, and then beginning of June, I'm only going to work 30 hours a week, all right? Or let's just say 35 hours a week, and they don't work the overtime, and they don't work any of that. Now you're going to be short at that 12-week period, and you have to guarantee it for the entire period. So really smart H2Bs and seasonal workers and J1s and college kids can also game it the opposite way. So they can say, listen, that's fine, I'll only take 20 hours, but I'm only working 35 in June. And I'm not going to work overtime for you. And so that way they're going to get a free check that makes up the other 15 hours that they weren't working in April and May. Yes?
You can't be explicit in the fact that overtime may be required if you put that in all your ads.
Right, but it's not required. It may be required, but it's not required. And if you want to say overtime is absolutely required in June, then you've got to do that for the American workers.
Well, yes.
Right.
It's a given, yes.
Yeah.
People that you hire for the exact same position.
Correct. Correct. That are doing the same, substantially the same work as the H2B occupation that you've asked for. Okay? And I don't know if you can, by law, actually say overtime is required.
May be required.
May be required, but I don't think that's grounds for termination if they don't do it. That's why I'm saying, at the end of the day, if they don't work the overtime in June and you're backloading the work because you don't have enough work in April, you're going to be on the hook if they don't work it. All right, some miscellaneous requirements. This is what Jane was talking about. The regulation states specifically that you will pay all visa-related costs during the first week of employment, and then we'll add to that by company check, or however you're going to do it.
Buttons, you give them buttons.
Okay? That there is absolutely no charge, and you will not, that you will furnish all equipment, tools, supplies. And you should all know that. That's a long-standing Department of Labor rule. If you require a uniform, you have to pay it. If you suggest a uniform, you have to pay for it. Okay? We really like everyone to show up in white, white golf shirts and khakis. Well, that's a uniform. Okay? And you're going to be found to pay for that. Copy of the job order must be provided. So all these benefits, all these rights, inbound travel, outbound travel, 3-quarter guarantee, all the benefits, you're helping them find housing, you've arranged for housing, you're helping them with daily transportation. Any assistance you're giving the H2B workers has to be on the ads and the job order. You must give the H2Bs a copy of that before they apply for a visa, if they're outside the U.S., inside the U.S. before they accept an offer of employment, and to all your U.S. workers no later than the first day of work as defined by your date of need. So you have to, and you're going to have it signed off by your U.S. corresponding workers, because you're going to need that in your audit file. Because if you're audited and you show that you had 4 H2B workers and 1 U.S. worker, you've got to prove that you gave that U.S. worker notice of all their rights and benefits. Okay?
And it must be in a language that they understand, so that according to the regulation. So if it has to be translated into a language that they can only understand,
You got to do it. There is going to be a poster notice that hasn't been created yet. You all know that you have to terminate. You have to provide a notice of termination to Department of Labor, USCIS within 2 days. USCIS, there's no strict requirement, but we tell our clients to send an email to Department of Labor and USCIS within 2 days. My clients are creating a customized earning statement and a customized earning record so that if you're audited, you can produce these documents within possibly 72 hours. Your audit file should contain, and again, you may have to produce this in 72 hours. You have to retain it for 3 years from the date of certification. At the time of the I-129 filing, you should have an audit file, and this is what our office is going to provide our clients. This is what Mark and Jane's office should be providing you at the time the 129's filed. Your registration and supporting documents, your prevailing wage, your recruitment report that was submitted, the job order that was posted, the 2 physical postings or notices to CBA, all the ads that you have to do, name, contact, disposition of all applications of all workers that applied, evidence that all laid off workers within the last 120 days were contacted, or 120 days from the first day of need, all written contracts with agents and recruiters, all agents and their recruiters' employees' names, their employees' names and contact, okay? All of that has to be, as a practical matter, Mark's office, Jane's, and mine, we need all that stuff to get to the 129 filing. So we're going to collect that for you, and we're going to hand it to you, or Mark's office will hand it to you. Then, this is what you have to do during the course of the employment. You get a document that you paid the visa fee, that all deductions and additions to pay were actually taken out, that you've already disclosed, that you took them out properly or you paid them, the bonuses you paid, all of that has to be documented. That you have an individual earning statement for all H2B workers. And that's going to be, and the earning statement, it's very specific in the regulations what has to be on an earning statement. What I suggest you also have in your audit file is an earnings record. All right, what's an earnings record? It's just a term I created. It's not in the regs, okay? But an earnings record should be if you have H2Bs every single week, depending on how many employees you have, you should sit down for at least an hour or 2 hours at payroll and create this earnings record. Earnings record will be every single H2B and corresponding employee, that's those people doing substantially the same job, that's categorized as being required to be given all the H2B benefits, all on a spreadsheet. And then you should have how many number of hours were offered that week, how many offered were worked, how many were declined. If it was declined, you got supporting documentation behind it, plus their individual earning statements to support it, plus a running 12-week tally that they're being guaranteed, let's say 315 hours. So you want to create this master Excel spreadsheet that you're going to fill out and you're going to put supporting documents behind. Do it every single week. Because I'm telling you, to do it when you're audited a year later, and if you only have 72 hours to produce it, you'll never be able to do it. So create this record of all your obligations in real time. You'll save everybody a ton of work and effort, plus yourself, because you're going to be creating the record as we go along. Good idea?
I think it's an excellent
Yeah.
idea, because when we get audits, and right now we're in the middle even for this last year.
Right.
The audits that they're asking and submitting now are more detailed than what they asked for before 6 months ago.
Right.
And they're shortening the time frame
Right.
from which you have to apply.
So these are two documents that you have to create. One is a very specific H2B earnings statement. And if you look up the regulations, it's very specific in there what has to be on the H2B's statement. So this is a separate statement you're going to create outside of what ADP or whoever your payroll company is. There's very specific stuff that has to be on that earnings statement. You have to give it to the H2B worker on every payday. Now, do you have to give it to all the corresponding U.S. workers? No, but you're going to, in an audit, they're going to request you to prove that you paid all the corresponding workers. So I've told my clients yesterday that you've got to create that H2B or corresponding employer earnings statement. You don't have to give it to the U.S. worker, but you better create one and keep it in the audit file. So again, once you're audited, you can prove that each H2B worker and corresponding worker got all the same benefits. So you have an individual earnings statement. And then you want to create this second Excel spreadsheet where you're logging every H2B and corresponding worker, number of hours offered, number of hours worked, first week how many hours were worked or offered or paid, and then keep the tally and just keep it going so that you can just produce this document. And if you offered and declined, there should be, footnote A that says offered on week 12, 35 hours, went to a wedding, only worked 30, and then here's the document that they signed that says I was offered 35 hours this week. I forfeited 7 hours because of X, Y, and Z. Okay? And if you're going to exclude incumbent workers, you should have documentation in there. So if you have 2 full-time, year-round dishwashers that are in with the H2Bs and corresponding workers, they work for you for a year, you better have records that show that they're an incumbent worker, meaning they've been a full-time worker for you for the last year, essentially, or 1 year up until April 1st of 2016. Copy of all termination notices that you've given to the Department of Labor, and at that point, Mark or Jane or our office will give you the approved I-129 petition. Stick that in that audit file. So the audit file has this stuff in it that we should give you, and then what you have to maintain and create and aggregate. Because it does state that they could only give you 72 hours. All right. USCIS, so that's all labor certification and obligations. Now, having said that, back in 2008 when we got these new regulations, it seemed incredibly daunting, and we were able to get through it. Again, I think our 3 organizations and anyone that does H2Bs and the big law firms in Boston that do H2Bs, if they read the regulations, they'll comply and they'll keep you compliant. The bottom line is, anyone that's doing the same job, you've got to give them equal benefits, equal rights. It's no longer, I want my 3 H2B Jamaicans here at all costs. It doesn't work that way. Okay? I know how important they are to your businesses, but the system is there so that you will hire that unemployed person in another part of the country and give them a fair shot at that job over that Jamaican worker. It just is, and that's the nature. I know that's not how you run businesses, because everybody wants incumbent workers. Everybody wants the same employees every year because it makes for a more efficient operation. We get it, but that's not what the Department of Labor cares about. They still believe that there's unemployed people in other parts of the country that should be employed here in Cape Cod, and you've got to make the effort to do it. USCIS, no changes. These are all the normal forms that you have to file every single year, but I gave it to all of you. It's in your PowerPoint. Just seeing if there's anything I see that's consular process. Last year was slightly better at Kingston, Jamaica. I think it was about 3 weeks. Everybody knows how you reset your 3-year clock. There were less, I thought, there were less consular fraud officers calling, or Kansas City consular office verifying H2B employment. I think we've all done a good job of making sure that the H2B employees are aware of where they're going, what they're about to do, what their wage is. So it's been that's been better. So they're not standing in front of the consular officer saying, "I'm not even sure where Cape Cod is," or who the right. So that's been better, or what state it's in, right? So this is the process. There's going to be delays. There's going to be tons of curveballs, as Jane has explained in her dealings with some of the other states. I think Massachusetts, at least in initial appearance, that they look like they're on the ball and they're going to do a good job. They've done a really good job in years past, so I expect them to be efficient. It's really a question of when Department of Labor is going to get them up to speed. One of the things that are delaying the processing is all the states' training by the Department of Labor on how to run the process isn't until the 15th of the month. So most of the states haven't even been trained yet on this new process, and that's going to happen this month. Half of the forms, like we said, the ETA 9142B hasn't even been drafted yet. The posting hasn't even been drafted yet. So all that is, there'll be a lot of changes between now and in January when you start your recruitment. We will, at the Cape Cod Chamber, whenever I see government notices, I make sure that we cleanse it and post it up there, or at least give you a link to the Department of Labor website so you can see what changes there have been. If you haven't signed up for our seasonal workforce email list, give your email address to Matt at the back, and he'll make sure you get all those emails. And we pass it along to everybody. We're not trying to hide the ball. Again, personally, I'm involved in the Cape Cod Chamber, but I'm an immigration attorney. I have no desire to take one more H2B client. I absolutely do not want any more. And I think my office will absolutely revolt and leave me. And we've got 99% of our business, which has nothing to do with H2Bs, and I can't afford to lose them. So one thing's going to go, it's going to be the H2B business that we have. Right? But Mark and Jane's office do a great job, and I'm in constant contact with them, and I make sure they get any information we get at the chamber and pass it along to all of you. All right. Are there any questions?
Would you please talk about the new regulations and make sure people know that your H2B workers are supposed to be terminated or laid off at the end of the season before the U.S. workers and before corresponding workers?
I didn't get to that part of it. So what was it? Mark, did you read that, Reg? I didn't see that they have to be notified prior to.
When we listened to a workshop with the Department of Labor, which was a challenge in of itself for 2+ hours, they made that very clear at one point of it, that if you have both U.S. and H2B workers, that your H2B workers are supposed to be let go before your U.S. workers.
Oh, I think what Jane referred to is in the event of a slowdown, not just at the end of the season, but say your business experienced a seasonal slowdown at the end of the year. Your requirement was to maintain the U.S. workers in their positions as long as possible, so that if there was going to be a reduction in the size of your workforce in that job title, that the H2Bs or the J1s had to be the ones that go first.
Right, so if you're at the end of your season, you do slow down. End of your peak season, end of your seasonal season, if you're open only seasonally, you don't say to the American workers, you're gone, October 15th, and your H2Bs stay till October 20th. It's reverse. And they were, during this online workshop we went to with Labor Department listening to, they kept stressing that, and people kept asking questions about it. The comments back to the questions were, you make sure your H2Bs go first. So what we are doing is we are telling all of our clients to ask their workers when they wish to leave and to get that in writing. So if John, the American, wants to leave on October 10th because he's going to go play someplace, or he's driving himself to wherever he's driving himself to go to work, or just doesn't want to work anymore, and the H2B worker doesn't leave until the 15th, you have it clearly documented that the American wanted to leave before you let the H2B go.
Right.
You weren't the one who told him he had to leave on October 10th.
In Appendix B, obligation number 8 states, employer has not laid off and will not lay off similarly employed U.S. workers in the occupation and area of intended employment within the period beginning 120 days before the date of need. So that's that layoff notice that we talked about. Through the end of the period of certification, unless the layoff is for lawful job-related reasons, and all H2B workers are laid off first. So that's what Mark's saying, is that during the middle of the season, if you've got to lay off people, you better start laying off, you better lay off H2B workers before US workers, all right? At the end of the season is the end of the season, so there's, everyone's got to get laid off. But if you have a reduction during the season, you've got to lay off the US workers before, and that's here. I did not see that in the regulations, so they may have added that ultra-virus, but we'll see, whatever.
It was more in the discussion, because the discussion on this call-in workshop we were doing with the Labor Department, people kept hammering at that, and they kept coming back and saying, don't lay off your Americans at the end of the season. If you're terminating everybody who's in your seasonal position, H2Bs go before your American. That's why we're saying, just to put in writing, have your Americans tell you the date they want to go. Have the H2Bs tell you the date they want to go. Not the date you tell them. They know the end of the visa is October 15th, so they're going to tell you, I want to go October 10th. I'm going to New York, or whatever the case may be, just to cover yourself in that regard. Because there was a big discussion about that, which sort of seemed rather silly to us, but, again, as Matthew said, this is about keeping American workers employed, not the internationals.
Yes.
So if we were to petition for housekeepers through the H2B program, but not, say, front desk agents or servers or shift engineers, whatever it may be, and we offer transportation
Oh, can you hand her the mic? I'm sorry.
to and from,
Can you ask the question again?
And I don't want it right up to
if we offer, she just said not to do that. If we offer travel arrangements and reimbursements for subsistence and other items for positions that we petition through the H2B program.
So it's
So
just-
say for
just-
housekeepers.
Just housekeepers.
We just hire housekeepers, but yet we have employed seasonally front desk agents, shift engineers, servers, whatever it may be, through other means. Are we equally as responsible for those reimbursements? Would it appear to be discriminatory?
For non-H2B jobs.
For non-H2B jobs?
Okay. Well, again, I'm an immigration lawyer. I'm not an employment lawyer. But I will tell you that you will not be in violation of the H2B regulations.
Right.
But you may very well be in violation of, you may be committing some type of discriminatory laws. So if it just happens that all your H2Bs are Jamaicans and they get this benefit of travel for temporary position, but your other positions are just as temporary, but you don't pay for any of them, could you be accused of a discriminatory practice? I don't know the answer to that. I think you've got to go to an employment lawyer. I would say yes and no. Yes on its face, but no because you're trying to comply with a federal program. So you would normally not pay anybody's travel, but you're doing it so only to comply with a federal program. So I think you would have an out, but I can't answer that for you. You talk to an employment lawyer.